Hello, Cybersecurity Law class, and welcome to Class 6 in our series on computer crime. In this class, we will continue our discussion of threats, cyberstalking, and cyberbullying. And to kick off our discussion of these issues, I'm going to show you a couple of videos. One is from an all too familiar scenario of cyberbullying in a junior high or high school context. And the second one is a rather frightening example of cyberstalking. So I'll show you these videos and then we'll come back and look at some of the materials that we've assigned for reading this week.
A sheriff in Florida has arrested two girls ages 12 and 14 on felony charges of aggravated stalking in a case of cyberbullying. A 12-year-old classmate jumped to her death a month ago, and Anna Werner has more.
Police say Rebecca Sedgwick was relentlessly tormented by two classmates for a year. The arrests were made after the 14-year-old suspect boasted on the internet about the bullying. Sheriff Grady Judd.
She made a comment in reference to, yeah, I bullied Rebecca, and yeah, she's dead, but I don't give a blank. We saw that and we thought, that's over the top.
The 14-year-old and her 12-year-old accomplice allegedly harassed Sedgwick at school, then followed her online. Taunts included, "You should drink bleach and die. No one likes you," and "You should go kill yourself." Sedgwick jumped off a tower near her home after writing friends, "I am jumping. I can't take it anymore." We spoke to her mother, Tricia Norman, last month.
I want them to pay for it because they took my baby away. They took her confidence away. They took her self-worth away. And now she's gone from me.
The sheriff hasn't ruled out charging the suspect's parents.
If you can't supervise your child, if they don't behave, then take away their devices. Don't allow them to have Facebook.
So who do you blame more here, the girls or their parents?
I blame them both equally. This incident goes way back until 2012, back in November or December, with fights, with intimidating, with terrorizing Rebecca Sedgwick. So the defendant's parents knew she was bullying.
The two suspects are now under house arrest. Scott, if convicted, the sheriff says it's unlikely they would face jail time because this would be their first offense.
Anna, thank you.
The dark side of social media, and one woman's nightmarish struggle over several years to elude her stalker. Hers is a chilling case, starting with the way she was approached with a friend request on Facebook from a former college classmate. Their interaction quickly took a disturbing turn, and then, as the ominous tweets and YouTube posts piled up, it took over her life. Here's ABC's Andrea Cannon.
Please just listen to me and let me be nice. We need to talk face to face.
The videos are disturbing and terrifying.
That's a very, very unwise decision. It's up to you now. Save your own life.
Patrick Mashoni posted dozens of threatening tirades on YouTube.
You stupid, ungrateful piece of...
all directed at one woman.
In sickness and in health until the day you die.
His obsession, former college student Kristen Pratt.
It stops you in your tracks. It just kills you emotionally.
For 3 years, Patrick Mashoni used social media as his weapon, cyberstalking Pratt through YouTube. Messages like these: "I want to tie your wrists together. I'm going to follow you home from work." And tweets like this one: "It is up to you now to save your life. I have no options." Not to mention dozens of phone calls a day. Pratt worried for her life.
Describe what that's like to be paranoid 24 hours a day.
Makes you question the world around you, and it instills fear.
Would you check the shower? Would you check the closet when you came home?
I would check all the time. I used to have dreams that he found out where I lived and broke into my house and waited till I went to sleep and would kill me.
It all began out of the blue in 2008 when Mashoni contacted Pratt, then 19 years old, on Facebook, reminding her they had taken a class together 2 years earlier at a community college. They had never even officially met. She says the conversation was initially polite.
You were innocently responding to him, thinking could be a friend.
Yeah, exactly.
But about a half dozen messages later, things quickly turned frightening.
They were more sexually oriented and a little bit more deranged. Stuff about how he wanted to kill me before I kill him. Or he would break my neck, my boyfriend's neck.
The stalking only escalated.
You're still playing games!
In this video, you can see Michonne videotaping himself in front of Pratt's work. She then drives by, not even knowing he's there. He chases her. Pratt was told outside of a restraining order there was little she could do until a police officer arrested Michonne for prowling at another apartment complex.
We asked if he could check Patrick's backpack. And in the backpack was a sexual device, condoms, porn, and a video camera.
Michonne was finally charged with cyberstalking, and last week Pratt faced him in court.
I was always nervous and frightened that at any moment I could walk out of a building and nobody would ever see me again.
What was it like having to be face to face with this man?
You're still playing games!
Really scary. I was breathless. It took my breath. I couldn't breathe.
You can't keep ignoring me. You can't.
Michonne was convicted of cyberstalking. He took a plea deal. The prosecution asked for 15 years, arguing Michonne is a danger to society if released too soon from prison.
I know what's going to happen. He will kill her.
The defense painted a picture of a once bright and promising student with a college scholarship who went on a downward spiral, a man who needs medical help, not prison time. Michonne, now 24 years old, admitted in court he has problems.
Well, I want to apologize to her, definitely for scaring her. I honestly don't even remember, any of those emails. Obviously you're not making it up.
The judge gave Michonne 4 years. He will be out in just 2 for time served.
He made it a point to say it was because this is Patrick's first offense. He hasn't harmed me. I'm still alive. But I'm not alive because Patrick didn't want to hurt me. I'm alive because I made sure I stayed alive.
Why do you think the judge didn't side with the prosecution, only giving 4 years versus 15, which is what they wanted? It's just a fraction.
Stalking cases and cyberstalking cases still aren't treated in the same way by the law as an actual assault. But in this case, the judge would say, well, I've taken away his weapon, and that is access to a computer, because for 15 years, he's on probation. Uses that computer in that 15-year period, he's going to have to serve the whole sentence.
Please! This isn't a game!
As for Kristen Pratt, her biggest fear is when Michonne is released from prison in 2 years.
Don't tell me I shouldn't be angry.
A judge has ordered he will forcibly have his medication injected because of his lack of cooperation. But she says the nightmare will never be over.
Are you going to live the rest of your life looking over your shoulder in fear?
Of course, always. There will never be a day when I will be able to walk down the street without worrying if he's behind me.
For Nightline, I'm Andrea Canning in New York.
So welcome back, and I think all of us can agree that both of those videos show some very disturbing cases, and I think for sure all of us probably will agree that in the second video, the case of cyberstalking, there's definitely a need for some kind of law enforcement response. We could debate, and perhaps we can discuss this in class, the extent to which there are issues of mental illness and the kinds of issues that arise in terms of whether some kind of imprisonment is appropriate, mental health treatment, how we deal with the victim. I think in the first video, it's perhaps a little bit more difficult to know, because it involves relatively young children, in what way the law should get involved. And I don't know about you, but I found the sheriff's officer's statement in his interview a little bit troubling. He seemed pretty strong on suggesting that there should be criminal responsibility for the young girls as well as their parents, and it's not entirely clear to me exactly what kind of involvement parents should have in these things. But these are things that I'd like you to keep in mind as we go through the materials that I gave you to read. And also keep all of this in mind as we look at some of the cases that we have to look at. How analogous are these circumstances? How clear-cut are all of the circumstances in some of the cases that we will look at. So first, let's look at some typical state statutes dealing with issues like threats, stalking, bullying, harassment, and how all these things play out in cyberspace. And we're going to look at statutes in New Jersey because those are statutes that I'm personally familiar with. They are typical of statutes in states around the country. There isn't really a model law on all of these issues, but I think you'll see similar kinds of things crop up. And as we go through these, I want you to think a little bit about what kind of activity, what kind of mental state, what kind of action, what kind of intent is required under these statutes, and how do these statutes interface with conduct that we might think is in some way disturbing or perhaps inappropriate, or at least some of us may think is disturbing or inappropriate, but that really is just part of the rough and tumble of living in an open society with a strong commitment to free speech. How do we draw those lines in these statutes? So the first statute I wanted to look at is the New Jersey harassment law. And you might be surprised to learn that New Jersey has a law that makes it a criminal offense, at least a misdemeanor, to engage in harassing conduct. And I want you to notice that this statute is not a cyber provision. This is a general harassment statute. So if you make or cause to be made a communication anonymously or at extremely inconvenient hours or in offensively coarse manner or in any other manner likely to cause annoyance or alarm or subject someone to this kind of physical contact or engage in any other course of alarming conduct or repeatedly committed acts with the purpose to alarm or seriously annoy another person, you are committing, in New Jersey, the crime of harassment. Now think about that for a minute. How often is this crime committed on a daily basis? How often might even you or I perhaps commit this crime on a daily basis? You might suggest that the entire process of going to law school is an exercise in being subject to harassment in some respects. I'm joking, of course, but you can see that there's kinds of conduct that we think, someone flips us the bird on the highway. Well, that might not be very nice, but I doubt that most of us would want to see that criminalized. Technically, it theoretically could be harassment under this statute. So notice how potentially broad this is. And certainly this kind of statute could cover online conduct. Now, very recently, within the past couple of years, New Jersey has added a provision to the harassment law specifically for cyber harassment. So notice the New Jersey cyber harassment law, making a communication in an online capacity via any electronic device or through any social networking site. So that would include, of course, your computer, your laptop, your phone, your tablet, any kind of electronic device, with the purpose to harass another. So there's an intent requirement, a purpose to harass another. And here are the various specific offenses: threaten injury or physical harm to person or property, knowingly send, post, or comment lewd, indecent, or obscene material to or about a person, or placing a reasonable person in fear of physical or emotional harm to his person, or threaten to commit a crime against the person or the person's property. So again, notice the potential breadth of this statute. This would include any kind of online posting, a comment on a Facebook post that could be considered lewd or indecent or obscene. And so let's think about the variety of kinds of comments that could be posted. And again, with the intent to emotionally harm a reasonable person. What is emotional harm in a statute like this? What would emotionally harm a reasonable person? Would a reasonable person, say on a Facebook page, expect a certain amount of back and forth that could be considered indecent or lewd or something like that, or not? These are interesting questions. There isn't case law under this statute yet. I think it raises interesting constitutional issues in terms of its overbreadth or vagueness and its relation to the First Amendment. Nevertheless, there it is. So New Jersey, like most states, also has a stalking law. And again, this is a statute that really arises out of the physical world, but that also applies in the cyber world. So one of the difficulties with a stalking kind of statute is going to be that we generally do have or expect rights of free speech, rights of free association, a certain amount of freedom to travel, and to a certain degree, a right to follow or pursue somebody. I mean, let's say that there's somebody that you're romantically interested in, and you see that they're going to a certain pub in that evening. You see them go in, you follow them inside, hoping that you get to meet them. Now, that might be totally innocent and not creepy. Or it might cross the line if it's a certain kind of conduct and become something like stalking, where it's disturbing, and it might become something that's disturbing enough that the law should step in. So generally, these stalking laws are looking at a course of conduct, right? So stalking isn't going to be one incident or even one or two incidents, but a course of conduct. A course of conduct in this New Jersey statute, repeatedly maintaining visual or physical proximity. So it's not just seeing the person go into the pub once and following them and trying to make contact and either succeeding in making contact or being rebuffed, and that's kind of the end of it. But repeatedly doing that, staking out the place, that kind of thing. Directly or through third parties or any action, method, device, or means monitoring, surveilling, threatening, or communication to or about a person. And there are varieties of cases involving things like GPS devices, involving the use of phones, other things like this to track people. Repeatedly committing harassment. So, as you might gather, harassment is one degree or level of a crime with certain kinds of punishments. Stalking would be a higher degree, a higher level of crime with other kinds of punishments. So repeated harassment can constitute stalking. Verbal or written threats that are repeatedly conveyed by any means of communication. So repeated threatening emails, repeated threatening Facebook posts, repeated threatening texts, all of these kinds of things can be stalking. And purposefully and with this course of conduct, purposefully or knowingly engages in course of conduct directed at a specific person that would cause a reasonable person to fear for his safety or the safety of a third person or suffer other emotional distress. They have all this kinds of conduct that's listed, or other kinds of conduct that might cause repeated conduct that might cause a reasonable person some kind of emotional distress. So notice that all of these statutes are focused on intentionally causing emotional distress to another person. And we have to, again, kind of ask ourselves, how much emotional distress are we willing to tolerate simply because we all kind of bump up against each other in society? And at what point do we say that some degree of intentionally caused emotional distress is, in fact, some kind of criminal conduct? Right, the next statute we'll look at in New Jersey is the luring statute. So, again, luring statute arises in the physical world, but it is, in a sense, often the use of electronic or virtual means to contact somebody or lure somebody in the physical world. So the statute defines as attempts via electronic or other means to lure or entice a person into, and then there's these various things: motor vehicle, a structure, isolated area, to meet or appear with a purpose to commit a criminal offense with or against the person lured or enticed. And so we looked at some examples last week when we were talking about child pornography, of efforts of some of these people in these chat rooms to actually meet up with these minors for the purpose of having sex. So having sex with a minor would be a crime. So if you're sending messages to someone who is you believe to be a minor, and you're trying to entice them to meet you in some kind of secluded space, like a dark corner of a park or something like that, for the purpose of illegal sexual conduct, that would be a luring offense. And this statute's kind of interesting in that it defines electronic means to include the internet. So it's casting a very broad net in terms of what kinds of electronic means can be covered, and it's targeted at this idea of using the internet to try and entice minors or other people into criminal conduct. The last statute that we'll look at in this section is the New Jersey bullying law. Some of you, I'm sure, are familiar with this statute. It got a lot of press when it was passed. And the thing that you ought to notice about this statute, or one of the things you ought to notice about this statute, is it's not a general prohibition against internet bullying. If there's general internet bullying, then and it's going to be actionable as a crime, or someone's going to be culpable for it as a crime, you're going to have to look at the harassment statute, the luring statute, the stalking statute. Those are going to be your general kinds of avenues. The bullying law is specific to the education context. So this is really a piece of education law. And so you can see from this definition in the statute, it's an electronic communication reasonably perceived as being motivated by some kind of protected characteristic, gender, sexual orientation, religion, various things like that, or any other distinguishing characteristic. So any distinguishing characteristic could be physical thing, haha, you're short, something like that, right? That takes place on school property, or, and this is really important, or off school grounds, that substantially disrupts or interferes with the orderly operation of the school or the rights of other students. So this is an education law provision, but one of the controversial and interesting pieces of it is that it covers what is on school grounds as well as what is off school grounds. Now notice that last phrase, substantially disrupts or interferes with the orderly operation of the school or the rights of other students. This language is trying to get at the potential constitutional problems with a statute like this, because students in public schools also have a certain degree of rights of free speech. And if you recall from your constitutional law class, if you covered this material, the Tinker case, cases involving students wearing black armbands to protest the Vietnam War, or wearing a T-shirt with a profanity on it, or other things like that, and schools trying to prevent that. And the balance that the Supreme Court drew in cases like that is to say, yes, students in public schools have a certain degree of free speech rights, but there is an important interest in the school in maintaining its order and function in ordinary discipline. And so that's kind of where you have to look at this kind of law in terms of whether it interferes with some kind of constitutional or other right of the students. You balance all of that against the need to maintain order in the school. So the big question is going to be, if this ever gets litigated, I think in particular, is whether something that occurs off school grounds, and what that might be, interferes with what happens in the school in a way that this statute could be enforced. And what they're trying to get at here, I think, at least one of the things I'm certain they're trying to get at, is the issue of social media. So there are kids engaged in cyberbullying, and they may be engaged in that from their home, not at school. But the implications of that cyber conduct spills over into then the real world of the school, and people get extremely upset, or it even, as we saw in one of our introductory videos today, can cause people to really despair for their lives, and that can disrupt the school. So how do you deal with that interface? Now, a statute like this, of course, can't penalize all speech that could be in some way considered offensive, but has to draw some kind of line. So what's the line that's drawn is whether a reasonable person should know that the speech or conduct will have the effect of physically or emotionally harming a student, or the effect of insulting or demeaning any student or group of students, or creating a hostile educational environment for the student. Now, we do have to draw some lines. Ask yourself how these lines are drawn, and we'll discuss this a little bit in class when we meet in person. But are these lines drawn well? What does it mean to emotionally harm someone? Is all speech that someone might find emotionally unpleasant necessarily bullying? What does it mean to have the effect of insulting or demeaning a student or group of students? What if you're talking about German history and someone like me who's a German, has a German family, and you're talking about the Holocaust, and you're talking about the complicity of the German people at the time in the Holocaust? Could that have the effect of insulting some German student? I suppose it could. Yeah, I wouldn't find it insulting, but I suppose somebody could. So is that where the reasonable person test comes in? How do we measure those things? I think it raises a bunch of really interesting and difficult questions. And the same thing with a hostile educational environment. That is kind of a catchphrase or a term of art in education law. And, what exactly does that mean? And when is an environment hostile? I think it's interesting to look at a statute like this in light of the protests that are going on right now on college campuses around the country. Now, this is a public education statute, deals with primarily with secondary education, but think about these things going on in college campuses around the country, and where are the lines drawn? When are these kinds of protests and concerns legitimate? When are they really efforts to stifle speech in favor of one particular political viewpoint? I think these are fascinating questions for us as lawyers. So what happens under the bullying law? The bullying law doesn't actually criminalize bullying. What it does is it mandates that local school districts have policies, and that those policies have certain requirements of reporting mechanisms. And the policies also need to have remedies, and those remedies include things like intervention, training programs, counseling, other action, which could include, say, suspending or expelling a student. It doesn't create criminal culpability. It doesn't, in itself, establish a basis for some kind of civil or tort liability. It simply mandates that schools have policies, that every school have a bullying officer who's able to take these complaints, look into them, do trainings, and so on. Now, again, this was a bit controversial, especially here in New Jersey. And if you are from New Jersey or are familiar with New Jersey politics, you may know that New Jersey has a long tradition of what we call local control. And local control means that each little municipality, presumptively, has its own school district. In many states, that's just not the case. There are only really regional school districts composed of multiple municipalities. Now, we do have some regional districts here in New Jersey, but the way the law is structured, it's generally difficult, very difficult, to impose some kind of regional district. In every little town, I mean, my little town of that I live in here in Bergen County, with 10,000 or so, 15,000 people, relatively small town in northern New Jersey, has its own school district of 100 or so students graduating in the high school senior class. And that's a very small school district, but we have that tradition here. And part of that tradition is to say every town should have its own local school board that should have at least some degree of flexibility to craft its own policies for the students in that district. So for the state, for Trenton, right, to come in and say, you must have this kind of policy and you must have this kind of officer, and that includes a hit to the school budget because you have to employ somebody to do that. That creates some interesting issues and interesting dynamics. I should say too, having children now in junior high and high school in New Jersey public schools, it's very interesting to see the trainings that are done for students on these bullying issues. As part of these programs that schools have to have involve training programs for students about what bullying is and why it's bad. My son in junior high in particular is very, very sensitive to these issues and is actually quite quick to call out his older brother and sister and even me sometimes and say, you're bullying, So it's kind of like bullying is the new smoking or something in the way kids get educated in these schools. Maybe that's a good thing. Maybe it goes a little too far. I don't know. It raises some really interesting questions. But as we've seen, there are some very, very real problems. And I think one of the themes, one of the questions that you ought to think about is, to what extent can law deal with these things? Or to what extent are these really a different kind of social issue that it's just very difficult for law to step into and deal with? And I think this, the first case that I want to talk about that I had you read, illustrates this in some very interesting ways. And this is the TV versus Smith Green case. Now, this is an interesting case on a number of levels. The facts are kind of interesting. And I have in the slide here sexting. They really weren't sexting, I suppose. I mean, they were, as the facts illustrate, these are these kids. They're having sort of sleepovers. They're goofing around. They're testing their boundaries. Maybe they're doing some things. Certainly, as a father, I would not be too happy about my kids doing, because they're kinds of activities that I think you can sort of get yourself in trouble with, but they're things kids do. So you can see from the facts what these kids were doing. And, the twist here is that these kids are on the school volleyball team. There are another group of kids on the school volleyball team who aren't involved in these activities. And you seem to also have different groups of parents. It seems like there's one group of parents who maybe is a little more tolerant of this kind of conduct. There's another group of parents who is not tolerant at all, apparently, of this kind of conduct, and it's causing these divisions among the kids in the volleyball team. And the school administration decides to get involved. Now, this is not a bullying case, right? But the school administration decides, well, we've got policies about the way our athletes are supposed to represent the school. So this, and the court seems a bit alternatively amused and annoyed that this case becomes literally a federal case. But the district judge decides it and says, well, this activity is happening outside of school. It's some kids at a slumber party. And it can't be said that this activity materially and substantially disrupts the work and discipline of the school. And as I mentioned before, part of this is playing off that Tinker standard. So, to what extent does the Tinker standard allow a school to regulate the speech of students? And the court, as you see from the opinion, goes through, is this speech? And the court does say, yeah, this is, even though it's kind of dumb and crude and all of that, it's protected speech according to this court. And this court says it's not obscenity, it's not child pornography. I mean, these are, little lollipops and things that are clearly not actual sexual conduct, this court says. So, how far does Tinker extend? Does it allow schools to regulate this kind of conduct? And that kind of question is going to, I think, continue to arise as we have these sort of virtual cyber issues that spill over into the school world. Everything from taking silly pictures at a sleepover party to real sexting issues to real serious bullying and harassment issues of the kind that we saw in the opening video. And the court says, this is at most 15 and 16-year-olds just kind of being 15 and 16-year-olds. And the school policy, and I thought this was a really interesting piece of this case, the school policy talked about whether out-of-school conduct could bring discredit or dishonor upon the student or the school, and that was part of that student-athlete code. And this court says that was overbroad and vague. And at least on this piece, I think I have to agree with this court. If you it's almost an Orwellian kind of speech. If you bring discredit or dishonor on the institution, you may be subject to discipline. On the other hand, query how many schools, public schools as well as private educational institutions, including even our own fine institution, may have codes of conduct that say similar kinds of things that might subject you to some kind of discipline. Now, some of those might be contract-based issues, but some of those overlap with these educational policy issues in a very interesting way. So the next case I asked you to look at was DC versus RR, and this is actually one of the kind of longest running sagas that I'm aware of in this area of what could be called cyberbullying. And we'll go through the opinions in this particular opinion, part of the case that you were assigned to read, and then I'll talk a little bit about other things that have happened in the litigation in this case. So you look at the majority of opinion in the case, and factually, you can read the facts in the case. You see that it's a young man, a high school student, who is involved in the arts, music, film, things like that. He has a MySpace page. Again, this was when MySpace was a place where budding musicians and artists, I think, posted a lot of stuff. But he had social media sites showing off his talents, and he had other students at the school then find this site and post some really vile comments about this student's sexuality, and containing what seemed like explicit threats to do this student harm. And so the context is the student and the student's parents, on behalf of the student, file lawsuits against the school district and against the parents on behalf of the other students who are harassing DC. And then the parents of those other students file an anti-SLAPP lawsuit. And some states, including California, have statutes that allow you to file a claim that a particular lawsuit has been filed for the purpose of cutting off free speech. That it's really not about the merits of the case, but the case was filed really to cut off free speech. And so essentially the procedural posture of the opinion you're reading is under this SLAPP statute saying the plaintiff's case against the individual defendant should be dismissed because it violates this SLAPP statute. It's not really a legitimate speech. It's trying to suit. It's trying to muzzle speech. And the majority opinion of the court says, no, it's not a SLAPP issue. And the question really turns on, were these comments on this kid's social media page, were they protected speech? Were they speech, for example, about someone who's put himself in the public light by putting his acting and singing materials out there so that people could comment on them, even comment harshly and in ugly ways, but still comment? Or were these true threats? And again, if you've covered any of this in constitutional law, you'll recall this. If not, it's relatively straightforward. You have the right to free speech. That right is not absolute. There are certain things, incitement to riots, for example, the government can regulate, and true threats the government can regulate. So the question is this true threats? And one of the interesting legal issues in this particular case is, well, what do we mean by what constitutes a true threat? Is it subjective, meaning that the person giving the speech actually intended a threat? Or is it objective, meaning a reasonable person would have perceived it as a threat, even if the person stating it subjectively may have intended as a joke or a parody or something else? So the majority says, well, I really don't have to decide that, because when I look at it either subjectively, based on the circumstantial evidence of the intent, or objectively based on what a reasonable person would have perceived, that these were real threats, and that the recipient of these could really feel that his life might have been in danger. further, the court says this is not matters of public concern. You have a lot more leeway in matters of public concern about what you can say or not say. And the court said this wasn't public concern, just the fact that this kid was interested in an entertainment career and had some things on a website doesn't alone transform it into a matter of public concern. So that's the majority opinion. Now the dissent says, no, wait a minute. Take all these messages and put them in context. And the dissent kind of lays out, as you'll see in the opinion, what each message was and how the messages begin, being unpleasant, but not directly threatening physical violence, not directly talking about the kid's sexuality, how they escalate. And the dissent says if you look at that pattern, it seems obvious that what this was an effort to be funny. That was a very misguided effort to be funny, but nevertheless was not actually an effort to threaten. And the dissent in particular says the subjective standard really has to govern. You have to look at whether the person making the comment actually intended a threat. And here, the factual context, and if you look at some of the language, is pretty extreme. The kinds of things that the commenters were threatening to do were so extreme that the dissent says they obviously didn't intend to ever carry any of that out. And if you any reasonable person, even under an objective test, reading that whole sequence would see that there's really no actual intent for any kind of threat here. Further, the dissent says this is a matter of public interest under First Amendment law. And the public interest standard, he says, is extremely low, and it can include gossip, and it can include tabloid kind of comments. So if you think about things like threat or things like an intent to cause some kind of emotional harm, think about those tabloid newspapers about celebrities and the things they publish, some of which are just plainly false. John Travolta's baby was abducted by aliens or something like that, right? That's not a threat, but those kinds of things, there's a lot of leeway for tabloids to say. You have other issues about defamation if they cross other lines, right? But you're dealing with a public interest, and the dissent says this is the same kind of thing. This kid was actually, it wasn't just any old website. This kid actually was in a movie. He actually did want to be an entertainer, and so there was some reason to comment on this. Now, I mentioned something about the whole long history of the case, and I want to show you now something from a blog post from a law professor out in California, Eric Goldman, who's one of the kind of top law professors in internet law. And if you're interested in all this stuff, follow Eric's blog. It's really super. But he wrote about some other developments in this case a couple of years ago, and I just want to show you that for a minute. So here, as I mentioned, is the blog post from Eric Goldman's Technology and Marketing Law blog on the DC versus RR case. And, as you can see, Eric says that in the course of his blogging over 8 years, reading hundreds or thousands of cases, this is one of his top 1% most interesting and memorable cases. And if you kind of look through the post, and I'll put a link to the post up on our course webpage, the litigation went on more than 8 years. And a couple of courts of appeals, a side suit for malpractice by DC's family against their attorneys. And one of the things that happened in the case is that the family sued the school district. The school district, there apparently was an agreement with families that went to the school that compelled arbitration. The court upheld the provision compelling arbitration. The matter against the school district went to arbitration. The family's claims against the school district were held by the arbitrator to lack merit, though not necessarily to be frivolous, but in other words, the arbitrator ruled in favor of the school district, but there was a fee shifting provision in the agreement that compelled the arbitration, and the family was required to pay over $500,000 in legal fees to the school district. This is the family of the boy who was harassed. That went on appeal to the court. The court reduced the fee award to about $200,000. And in fact, the family had to satisfy, and did satisfy, that fee award of about $200,000. On top of that, then there was a dispute between the family and their attorney, their personal attorney, for about $120,000 in unpaid legal fees. And that arose in the context of a malpractice claim against the attorney. So the family is on the hook for about $320,000 in legal fees from their own attorney and from the other side. So a really pretty terrible result, given that, however you look at the case, the family didn't do anything wrong. The kid didn't do anything wrong. And, as Professor Goldman mentions, the case shows how ill-equipped our legal system is to deal with cyberbullying. So the time and expense of litigating these cases, the uncertain result, the possibility, at least in this district in California, that you might end up getting hit with a legal fee award against you seems insane. Now, if you look up the parties, if you read some of the case, if you go on Westlaw and look at the case, you'll be able to find some of these underlying cases in which the parties are actually identified. The kid involved in the case does have a credit on the Internet Movie Database. He has one credit. He has a couple of videos, I think, on YouTube. It doesn't appear that he's had much of an entertainment career beyond that. Notice that the litigation went all through the high school years and all through their college years. They're long since out of college now. The father, I believe, if I'm getting the person right, is actually a well-known Hollywood movie producer and director. I don't know how that plays into the case, and hopefully they had enough money to satisfy these judgments. But regardless, I think if you look at this is a result that, at least to me, seems kind of crazy. Okay, the last case I asked you to look at was Miller v. Mitchell. This was a celebrated case when it first came out. It was one of the earliest examples of law enforcement getting involved in trying to deal with a high school sexting kind of scandal. And we looked at a couple of those in our previous class, and we had some good discussion about that. So, here's a case where law enforcement tries to get involved and says that, well, if you're sexting, you're a teenager and you're sexting, you've got child pornography. You've got distribution and possession of child pornography. And so to try and break this up, the local prosecutor working with the school district says, well, you need to write a paper explaining why your participation in the sexting activity was wrong. And if you do that, we won't prosecute you. But if you don't do that, we may prosecute you. And the gets up to the Third Circuit, and the Third Circuit ultimately says that would violate the minors' First Amendment rights. To require them to participate in that kind of remediatory activity might cause them to express opinions that they don't actually agree with. They might actually think it wasn't morally wrong or socially wrong. And there were a number of other things, if you read the case, about the program, which included things about gender roles and so on, which I think made it very difficult for the court to swallow. Further, the Third Circuit said the district attorney's motive for bringing this was for threatening to bring prosecution was actually retaliatory for not doing something that would impinge on First Amendment rights. And there's some kind of complicated law about prosecutorial discretion and when a prosecutor can choose to bring or not bring or threaten to bring a case. And so the notion that a prosecutor might threaten to bring a case in order to force someone to speak in a way that they don't want to speak is very difficult here for the Third Circuit to swallow. And further, the Third Circuit said there was no probable cause for the potential pornography charge, child pornography charge, at least on transmission, because the evidence of who transmitted the pictures to whom was kind of lacking. I think that piece of the Third Circuit's opinion is not really that strong, but the other pieces of the opinion, raise all these kind of interesting issues. Now, why do we bring up this kind of child pornography sexting case here in the context of our bullying, threats, stalking, harassment? I wanted to bring it up here because so much of this kind of conduct, certainly not all of it with stalking, but a lot of it with threats and bullying and harassment, occurs with young people and is kind of first discovered in this school context. And the big question I think it raises is, what can law enforcement do about it, if anything? What if the people engaged in the conduct, or at least some of the people engaged in the conduct, think it's actually part of their free speech rights? What if it's even speech that most people would think offensive? But nevertheless, if the First Amendment protects anything, it protects speech that most people probably think is offensive. But at what point does it become something that crosses the line from speech that is, just something that a lot of people will think is offensive to something that's really dangerous and damaging in a way that the law ought to step in? And so here are the issues that I'd like you to think about as we move toward class next week. So, how do we draw this line between problematic conduct and free speech? How do we draw lines, or should we draw lines between conduct that involves only adults or conduct that involves only children? Of course, we'll have another set of concerns if it's adults engaging with children. What if it's just children or minors, engaging with just minors as opposed to adults engaging with adults? Do we draw lines? And finally, what kind of remedies are there? If we do see that there are some kind of social problem that should be addressed, how should it be addressed? And in what way, if at all, should the law be a vehicle for trying to address it? That's the end of the lecture, and we have one more lecture to go this week, and then I will see you in class next week.